Trump's newest problem is Colorado.
State Supreme Court said today that Trump is an insurrectionist who is legally barred from being on the ballot. But the justices are essentially inviting the U.S. Supreme Court to keep him on the ballot while they review the case. So on top of Trump's 91 pending felony charges in criminal cases, he now needs the U.S. Supreme Court to take up this civil case out of Colorado, one where Republican primary voters successfully argued that Trump incited the January 6th insurrection, and that bars him from office under the 14th Amendment. The district court ruled, and the state Supreme Court today upheld that the facts of this case met the high bar of clear and convincing evidence.
Well, I think that the civil and criminal differences are significant here. There's no fundamental right to be a presidential candidate, unlike where your liberty interest when you're a criminal defendant. And so we think and hope that the U.S. Supreme Court does what the two courts that have heard this case so far have done in Colorado, which is thoughtfully and carefully look at the facts and the law, and we believe the conclusion is clear.
Our Jennifer Meckles has analysis tonight from a legal expert and a look at how these next steps could play out.
First, those who are Marshall Zellinger, who covered this case from the start, to examine why the justices made this historic decision.
The Colorado Supreme Court is made up of 7 justices, all appointed by Democratic governors. And this decision to disqualify former President Trump from the primary ballot was a split decision, 4-3. They determined that he did engage in an insurrection, and that disqualifies him based on the 14th Amendment. No different than being disqualified for not yet being 35 years old or not being a U.S. citizen. The 4 majority justices wrote, "We conclude that certifying an unqualified candidate to the presidential primary ballot constitutes a, quote, wrongful act," meaning Republican and unaffiliated primary voters in Colorado should not be able to vote for someone if they're not qualified in the first place. In dissent, the Chief Justice disagreed that insurrection can be decided by a civil court. He wrote, "My opinion that this is an inadequate cause of action is dictated by the facts of this case, particularly the absence of a criminal conviction for an insurrection-related offense." Of the 213-page opinion, I found an interesting tidbit on page 33. The 4 majority justices quoted former federal judge Neil Gorsuch, now Supreme Court Justice Gorsuch. It was a previous case in Colorado where a presidential candidate was disqualified from the primary ballot for not being a U.S. citizen. And the quote from Gorsuch defended the state's ability to make that decision. Marshall Zellinger, 9 News.
So if the Supreme Court is the likely next step here, what does that look like? We asked a constitutional law expert to weigh in on a couple of questions as we look ahead to this case if it ends up before the country's highest court. We start with this question. What are the federal questions in this case that the Supreme Court could even review?
There's the question of whether or not the presidency and the president is an office or an officer of the United States under Section 3 of the 14th Amendment. There's the question of whether or not he engaged in insurrection. There's the question of whether or not the First Amendment protects his speech. All of those are federal questions that the U.S. Supreme Court can reach.
The Colorado court determined Donald Trump was disqualified from the primary ballot because he engaged in an insurrection. How can the Supreme Court weigh in on questions of insurrection?
It could take Section 3 of the 14th Amendment, and it could say it means A, B, C, D. And one of those things could be that it requires a criminal conviction, or that it requires a legislative act, or that it requires some sort of jury trial, or any number of things. It could basically do the same analysis that the Colorado Supreme Court did and come to different conclusions about what the 14th Amendment actually requires.
Courts have ruled against similar efforts to get Trump banned from ballots in other states. So what does this decision out of Colorado mean now?
There are a couple of states that have reached kind of similar questions, but no state has gone as far as the Colorado Supreme Court has gone. So I'm interested to see what other states do with the Colorado Supreme Court's opinion, and if we see follow-on lawsuits, challenges, opinions in the next few weeks, months, that type of thing.
I also asked Smith how fast this moves. She said she expects Trump's legal team to petition the Supreme Court in a matter of days if they haven't drafted most of that already. But Kyle, there's also another option. They could not. Trump's legal team could say this just lies here in Colorado, and that might mean something kind of interesting too.
Yeah, I mean, they could just walk away and say, well, we're not going to win that state anyway, so we just won't appear on the ballot there. But the temptation would be too great then for
all the other states.
All the other states to come in and say, well, look what Colorado did. We're going to take them off here, 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 and here. Yep. So on to the Supreme Court we go. Jennifer Meckles, thank you. The Colorado Republican Party fought this case along with the Trump team. State Chair Dave Williams told me today, quote, "Thank God the U.S. Supreme Court will get the final say against the out-of-control radicals in charge of Colorado who would rather spit on our Constitution than let the people decide which candidate should represent them in a free and fair election." End of sentence. Now note the reference to a free and fair election if Donald Trump is on the ballot. This is interesting because that same man, GOP party chair, recently said that Colorado does not have any fair elections. And the party has suggested that Colorado's elections are rigged.
2 other state courts have faced similar cases, and they've made very different decisions. Last month, the Minnesota Supreme Court decided the state party can put anybody it wants on its primary ballot. It dismissed the lawsuit, but said the plaintiffs could try again after the primary. A judge in Michigan ruled Trump's eligibility for the ballot is a question for Congress and not the courts.
The liberal group behind that lawsuit's appealing, just filed a similar lawsuit in Oregon. Trump's campaign spokesperson is promising a quick appeal of this Colorado case to the federal Supreme Court. The Colorado Supreme Court said that Trump is going to stay on the ballot here so long as the U.S. Supreme Court quickly takes up the case.